I got to do one more thing outside your presence, okay? So let's take our afternoon break. I'll call you right back in. Requested a short 7:05 hearing with the witness. So, Ms. Anderson, I'm going to let you go first.
Okay. Dr. Arambula, how are you?
I'm good, thank you.
Dr. Arambula, have you received any additional records since we spoke, or actually since you wrote your report in April of 2026?
Yes.
What records have you received?
Numerous reports by your expert witnesses. Some of the notes, I didn't review all of them. The handwriting, I think, of Dr. Ryan was not as bad as mine, but I had trouble reading it. And then, let's see, I looked at the testimony from Cassie as well. And then I just listened to Billy's testimony today.
Did you listen to any of the experts who testified in this matter?
Briefly, there were two that I was able to follow about an hour each one.
Who was that?
The first one, I think it was Dr. Specht. I'm not sure. He was from A&M.
Dr. Edens?
That's it. That's him. Yes, sir. He might have been the first witness you had. And then briefly, Dr. Ryan last week sometime when she was on direct.
Okay. Based upon, and which, you said it was an interview of Cassie. Which interview?
It was actually not an interview. It was, I guess, court testimony from Cassie Wyatt.
Okay, do we know, was it her civil deposition? Was it the hearing that we had in this court? Which hearing are we talking about? It
was, as I put together, related to this case, so not the civil suit. I didn't know there was one.
Oh, let me ask you this. When you looked at the transcript of that, were there lots of black lines on certain pages?
Yeah, there were some holes. I can't say that I remember big black lines standing out, but there were holes. That's the best what I remember. Okay.
What do you mean when you say holes?
In other words, it wasn't confluent. There were gaps, so to say.
So it wasn't the complete transcript?
It looked fairly complete except for maybe some omissions or things that were either not transcribed or something like that.
We had a hearing that began in December of 2025 and continued in April of 2026, wherein we discussed your testimony and your findings. Do you have any additional findings or conclusions in addition to the report that you've already produced?
Yes.
And what are those?
Based on me looking at the records again, I remember that hearing where I hadn't reviewed for that, and the expert reports, the transcript, the testimony today. I do have an opinion regarding future danger.
And what is that opinion?
That based on the evidence, there is a probability that Mr. Horner will commit violent acts and constitute and be a continuing threat to society. I think I'm paraphrasing the statute, but I don't remember it by heart.
What do you base that on?
On the statute. In other words, it has to do with the statute regarding future dangerousness in sentencing hearings.
I understand that, but I'm asking, upon what evidence are you
Oh, I
basing
see.
your
Okay.
opinion that constitutes a continuing threat?
So previously, I expressed concern about his temper, his ability to control himself, the outbursts he had. I think I mentioned his attitude towards women in general, based again on the audio recording that I listened to regarding his mistreatment of Athena. And then after looking at the rest of the reports that from the experts you provided, it was clear that he had some issues with executive dysfunction, difficulty with emotional processing, self-regulation, basically anger, so to say, and that he was also impulsive. And so because of their reports and the evidence they provided in those reports, coupled with my concern already about his ability to manage stress, control himself, his behavior, and particularly keeping in mind what I heard regarding what he did to Athena, that was the basis for my opinion.
Are you going to render an opinion on any particular diagnoses that you feel would be appropriate for Mr. Horner?
Well, if anyone asks me, sure.
What diagnoses
Okay.
do you feel would be applicable to Mr. Horner?
So based on let's see, let me state it this way. So when I submitted my report, I had reviewed records that covered approximately 20 years of his life, perhaps more than that. And based on that information, I rendered diagnoses of depression, anxiety, longstanding. I didn't point out in the previous hearing that, per the records, major depression recurrent was something that came up, unspecified anxiety. There may have been some features of panic attacks, but nothing was really codified in a diagnosis. Additionally, and I think I stated in my report, I suspected that there were some traits of PTSD based on the sexual assault he endured as a kid that he didn't want to talk about, but I still nevertheless included it as a possibility, not necessarily a disorder per se. Based on the records I reviewed up to my report, the diagnosis of ASD had been, I guess, by testing closed, that door was closed, so to say. In other words, the two psychologists concluded he didn't have it. But after looking at the reports from your doctors, who probably see ASD a lot more than I do because they see kids, I didn't have any issues with that. At the time that I looked at the records and interviewed him, there was an uncertainty on my part about how restrictive and repetitive his behaviors were, his interests, and that's one of the components and the criteria for ASD. But I knew he had some social issues. I mean, he'd had that all his life. But you have to meet two, and that's why it looked like he didn't meet the criteria. But once again, your experts, I don't have any issue with their diagnoses because they collected a lot of evidence and they see it more often. I spoke about personality pathology. That remains the same. He has significant features of antisocial personality pathology. There may be some borderline personality pathology undercurrents in there as well, perhaps narcissistic, and that's about it. And lastly, after my evaluation, I was not very impressed with the amount of drugs that he had been using before. He rather minimized that, and so I took his word at face value. And I saw some inconsistency in the records regarding his drug use, but your experts, particularly Dr. Ryan, uncovered a lot of evidence that he was using drugs a lot more. So I didn't identify any particular drugs. I just knew that he was using marijuana, cocaine all of a sudden, and it looks like there were some hallucinogens as well.
What about paraphilic disorders?
The same. He has some features of sexual deviance, and I refer to that. That was based on what I listened to in the audio tape regarding what he did to Athena. And then this morning or this afternoon when I heard Billy talk about it, that would infer that there's been some aberrant sexual interests that have been longstanding.
So it's your opinion that if something happens when a child is 10, that can create a long-standing issue when that person is an adult and does something like this at the age of 30?
Not necessarily, but it's unusual for somebody to exploit somebody like that, particularly when there's a 3-year difference, the size is different, there's a lot of force involved. I had expressed some concern regarding how forceful he was during sexual activity with his peers, and that's normal as long as everybody's consenting. But there was a question about Cassie, saying not, I'm apt to stop here, so he was perhaps pushing the limits more. And then when I read her transcript, she talked about some of the role-playing that they did. In particular, what caught my eye was when they role-played that he was her daddy and she was a little girl, which could very well resemble what happened between him and Athena.
But you would agree with me, though, that that's not terribly uncommon. I mean, we see movies back from the 60s and 50s talking where a woman is calling her paramour daddy. Right.
The role-playing per se was consensual. It was like people explore, but I can't disregard the similarity between their role-playing and then him acting out in a sexually deviant manner with Athena. And it's not unusual where that sometimes can occur when somebody acts sexually deviant towards another. You're right, it doesn't mean that it's going to happen, but those can be some warning signs when they show up in the records or somebody self-report.
And so you've read the records, you've read the reports from all of our experts, so you know that around the time that this happened with Billy, that Tanner himself had been sexually assaulted in a similar manner.
Yes.
And that wasn't of any significance when you looked at both of them?
The significance that to me was clinically apparent was the difference in ages. And when I say that, in other words, if Tanner had been at that age, at whenever, 13, 12, whatever it was, 10, acting out with another 10-year-old or a friend from school, that happens. But when that type of activity occurs with somebody that doesn't want to participate, there's a big difference in size, between let's say a fifth grader versus an 8th or 9th grader. That's a pretty big difference in developmental years. So that is a bit different. I'm not saying that laid the groundwork for what he did, but I didn't disregard it, and it certainly caught my ear, given the types of individuals I've evaluated in my sexually violent predator hearings that I participate in.
I'm sorry for interrupting. In this particular case, we're dealing with a 10-year-old and a 7-year-old.
Right.
So we're talking about two prepubescent children.
I understand that.
Okay. You keep trying to put him in different grades. You'd agree with me that you're not going to find a 10-year-old in the 6th or 7th grade?
Probably not.
Okay. Have you made a diagnosis that Tanner meets the diagnostic criteria for any of the paraphilic disorders?
No.
Have you made a diagnosis that Tanner meets the criteria for antisocial personality disorder?
No.
So the only thing that you're here to testify to is that Tanner, based upon the records that you reviewed, that there's a probability that he would commit criminal acts of violence that would constitute a continuing threat to society.
That's my opinion. The change in my diagnosis was that based on the evidence your experts collected, I didn't have any issue with that.
regards to the records that you reviewed, did you review all of the records from the Wise County Jail?
Not all of them, no.
What records did you review from the Wise County Jail?
Whatever was sent to me, so there were notations of incidents, like for instance, the suicide attempt. I reviewed that. There were some mental health records. I think it's Helen Therapy Center that provides mental health treatment to the detainees in jail. So I read all of those. If there's something else, then I didn't see that.
What about records from Tarrant County?
Yes, I saw those.
What records did you review from Tarrant County?
Up until, in other words, there were 2 periods when he was receiving treatment from Tarrant County MHMR. I want to say one was 16, something like that, and the other was more recent in 22, when he sought treatment again. Up until October was his last visit, I believe.
One moment. Dr. Arambula, just one last thing, and it had to do with the records. Did you receive any of the Tarrant County MHMR records from the state?
Yeah, they're listed in my report, and I haven't reviewed any subsequent records from Tarrant County MHMR.
Okay. Lost his, pardon me, Doc. I've lost your report amongst all my papers. Hold on one second.
Okay.
Do you have a supplement or an addendum to your report that includes all of the documents that you reviewed?
No.
I think that's it, Your Honor.
Mr. Berry?
Yes, Your Honor. Dr. Arambula, are you, in addition to the diagnosis that you've already stated in your report, and then just regarding the possibility of future dangers, and in your questioning with Ms. Anderson, are you also going to offer, some characteristics that are found in both the paraphilic disorder and the personality pathology that you observe potentially in Tanner, whether or not he meets the full diagnosis, full criteria to be diagnosed with those disorders?
If asked that, yes, I can answer.
Your Honor, other than that, I don't have any further questions.
Any further questions?
No, Your Honor.
Dr. Arambula, if you'll go with Deputy King for just a few minutes, we'll call you right back in, okay?
Yes, sir.
Any objections?
Yes, Your Honor. We don't have any objection to the doctor's qualifications. We know he's qualified. However, he has specifically stated that Tanner was not diagnosed with a paraphilic disorder. Therefore, it would be confusing to the jury to start talking about what symptoms there might be. If it wasn't diagnosed, it's not relevant. Same with anything with antisocial personality disorder. If we're talking about symptoms, it's not relevant because the doctor has already said that Tanner does not meet the criteria for antisocial personality disorder. We also have a couple of other things with regards to Dr. Arambula. One is he's used the term sexual deviance. That's not a diagnosis for the DSM, and if he were to be able to use the term sexual deviance, again, it can confuse the jury. Same thing if he were to try to use the phrase psychopathology or psychopathy. He has done that in the past in previous trials, and so we would ask that he not be allowed to speak about psychopathy for several reasons. One, it's not a diagnosis, and two, if he's allowed to speak about that, then it could confuse the jury. And Your Honor, there is ample research that shows just how prejudicial calling somebody a psychopath or speaking of psychopathy is. In fact, the research has stated that it's almost as prejudicial as referring to someone as a pedophile. So we know that the research supports the prejudice that it causes, and so we're asking the court to order the witness to basically stick to the diagnoses that are in the DSM. Same thing with sociopathy. It just goes along with the line that it is not a diagnosis per the DSM, and allowing the doctor to speak in colloquialisms, one, is going to confuse them, and two, creates a false impression in their minds as to the symptoms that Tanner may or may not have, and three, is unduly prejudicial, and the prejudice is clearly outweighs any probative effect.
The objections are overruled. You may cross-examine him on those statements. Let's take 10 minutes. We'll start up at 10 minutes to 3.
On that end.
All right, everyone may be seated. Ladies and gentlemen, this witness has been previously sworn to testify truthfully. Mr. Berry.
Thank you. Dr. Arambula, welcome. Will you please introduce yourself to the jury?
Sure. So my name is Dr. Michael Arambula.
And what do you do for a living, sir?
I'm a physician, a medical doctor.
And may I approach, Your Honor?
Yes, sir.
Dr. Arambula, as part of your involvement in this case, were you asked to provide a curriculum vitae with your background and education and some other accomplishments as well?
Yes, sir.
And did you also, as a result of your evaluation of the defendant in this case, write a report?
Yes.
And did you also provide us with handwritten notes that you had made during that evaluation and after, in preparation for writing the report?
Yes.
At this time, Your Honor, I'll offer in evidence State's Exhibit number 311, curriculum vitae, State's Exhibit number 312, the report of Dr. Arambula, and State's Exhibit number 313, the handwritten notes of Dr. Arambula.
No objections.
States Exhibits 311, 312, and 313 are admitted.
Dr. Arambula, I'm not going to take a whole lot of time going through your curriculum vitae, but can you give us sort of an abbreviated version of what your background is that qualifies you to make the diagnosis and opinions that you're going to give today?
Okay. So I'll make it quick. I attended the University of Texas at Austin and received 2 degrees from the College of Pharmacy. The first was a Bachelor of Science in Pharmacy, and then later I received a Doctor of Pharmacy. As far as why I'm a physician, I attended medical school at the Health Science Center in San Antonio, and I remained there for my internship and then residency training in general psychiatry. I completed that in the summer of '91, and then I spent a year in fellowship training, that's subspecialty training in forensic psychiatry in Chicago, and that was at Rush Presbyterian St. Luke's Medical Center. That was a year-long fellowship which I completed in the summer of '92. I've been back home ever since, and I'm also board certified in both general and forensic psychiatry.
So having this dual, you have 2 different medical doctor degrees, correct?
2 different doctorates, yes, sir.
Yes. So with regard to your work in this case, I just want to ask you how you became involved in this case to begin with.
What I vaguely remember is that you called my office, I think it was in probably January of 2023, and arranged to meet in my office to discuss this case. after which you retained me to work on this case alongside of you, looking at records and then ultimately evaluating Mr. Horner.
And are you paid for your services related to this case?
Yes, I am.
And what is the total amount of payment for services rendered so far?
So based on the last invoice that was sent, I believe it's $28,400, maybe a little bit more than 400.
Now tell us a little bit about your experience dealing with psychiatric patients.
Well, I've been in practice a long time, so as part of my residency training and then private practice, and I still have a private practice. I see predominantly outpatients. Collectively, I've seen thousands of patients who have different types of mental conditions. So that's it in a nutshell.
Have you evaluated persons that have similar mental illness or / mental conditions that you have seen in the defendant in this case?
Yes, sir.
Have you also evaluated people that have different personality pathologies like you have seen in the defendant in this case?
Yes, I have.
And as far as criminal cases, kind of talk to the jury just real quick about what you do related to criminal cases.
Okay, so criminal case-wise, I've been in probably a few hundred criminal cases. And over my career, earlier in my career, I worked predominantly for defense, and then in the last probably 10, 11 years, predominantly for the state or the DA. I've evaluated individuals for competency to stand trial, for example, insanity, mitigation for like probation, sentencing, and I've done some evals for federal judges. A couple of federal judges asked me to evaluate someone representing both sides regarding their capacity to waive habeas corpus.
So with regard to this particular case, you said that you were asked to look over some records. Do you have a list of those records in your report?
Yes, sir.
Okay. And I'm not going to ask you to read those, but just so the jury knows, those are listed in your report on page 1. Is that correct?
Yes, and those are the records that I reviewed prior to and as a basis for the report that I submitted to you in April of this year.
And we're talking about April of 2026, correct?
Yes, sir.
So now, at that time, was that report rendering opinions and diagnosis based upon an evaluation that you did of the defendant?
The defendant and also the record review of Mr. Horner.
So with regard to the record review, I want to ask you some specific questions. At the time that you did the record review and also the evaluation of the defendant in this case, did you know at that time that he was going to plead guilty to the offense when it came time to go to trial?
No.
And does that create some limitations with regard to whether or not you can give a complete evaluation of the defendant regarding punishment special issues?
No, sir, because of the evaluation that I conducted, and before the evaluation I discussed with Mr. Horner that it would probably be related to guilt-innocence and maybe sentencing after. So because of that informed consent, so to say, I collected information regarding both. I just didn't submit a sentencing report, so to say, because he hadn't pled guilty, or I didn't know what was going to happen, so I wasn't going to do that.
Understood. So the type of report that you did submit to the court was based upon your knowledge at the time, which was that he had not pled guilty. Is that correct?
Yes, sir.
And in fact, up until that time, pled not guilty. Is that right?
Right.
Now, what records, talking about specific records that you reviewed, did you review audio and video recordings in this case?
Yes, sir.
And can you kind of talk about the kind of basic audio and video recordings that you reviewed in this case? So
the audio video recordings were the investigative records, and that had Mr. Horner riding in his FedEx truck before this crime. And then I also reviewed the audio and some of the visual of the day of the crime. When I say some, because there were times when he would cover up the lens with what looked to be a sticky. And then I also reviewed subsequent audio-video recordings after the crime.
With regard to...
One more.
Pardon me, sorry.
And then I looked at the audio-visual recordings of the detectives who were interviewing Mr. Horner afterwards. I believe there were 2 of them.
And did you also have access to some sworn statements in the form of deposition or prior testimony in this case that you've had an opportunity to look at?
Yes.
And did that relate to persons that were family members or close associates with the defendant in this case?
Yes, sir.
And do you consider those to be collateral sources as far as your opinions go in your evaluation of the defendant?
Yes, they are.
Did you also have access to mental health, education, medical records of the defendant leading up to his arrest on December 2nd of 2022?
Yes, sir.
And are those also considered collateral sources that you used in making your diagnosis and opinions regarding the defendant in this case?
Yes, that's correct.
With regard to, are there a number of your findings in your original report that are based solely upon that documentation that you had prior to that time?
Yes, that's the basis for my opinions.
Now, as far as the investigative agencies that you referred to, did you receive records from all the different agencies that were involved in the investigation and the apprehension of the investigation of the murder of Athena Strand and the apprehension of the defendant in this case?
Yes, sir.
And did you also review some records related to prior sexual assault victims that came from the Fort Worth Police Department here in Tarrant County?
I did.
Are those also considered by you to be collateral sources which you use to render your opinions and make your diagnosis in this case?
Yes, sir.
Now let's talk about what were you asked to do pursuant to a court order by Judge Gallagher in this case?
Pursuant to that order, as best as I can remember, it was to conduct a mental health evaluation of Tanner Horner relative to the criminal proceedings going on at the time.
And at that time, you were focused on possible guilt of the defendant, is that correct?
Guilt, and well, it's not for me to determine, it's the jury, but yes, it was the guilt-innocence phase of the trial.
And what date did that evaluation take place, or well, the interview take place upon?
It was February 27th of this year.
And where did that interview take place?
In this courtroom?
So here in this room, is that right?
Yes, sir.
And who all was present during that interview between you and the defendant?
So obviously myself and Mr. Horner, there were 3 deputies, but they weren't standing next to us, but they were in the courtroom. And then Ms. Anderson came in and out periodically when Mr. Horner, we took a break so he could talk with her.
And so at that time, did you have a discussion at the beginning of that process with the defendant regarding the parameters of the interview you were conducting and what that information could be used for?
Yes, sir.
Could you kind of describe that for the jury, please?
So again, per my training, I do this with every case. I discuss who I am. I'm not here as a treatment provider. Who retained me? In this case, it was the state or the DA. That it was a court-ordered evaluation, and there were a couple of guidelines associated with that because it's court-ordered. One is that the information we talk about may not be confidential, i.e. the judge wanted a report, and so I was going to put it in the report, and if it came down to me testifying, then again, the information would not be confidential. And then the second guideline in these kind of cases is that when I asked Mr. Horner something, he didn't have to answer it if he didn't want to.
And so, were there some occasions where that actually happened?
Yes, there were.
So I'm going to kind of just have you tell me sort of in general about the level of cooperation that the defendant gave you during that interview for the evaluation.
So generally speaking, he was pretty cooperative. There were some areas that he was not cooperative with, and so we had to take a break. And then with each successive break, he became less cooperative and worked up. And so I didn't pursue the last time that he didn't want to talk about something. I just let it go.
And so if he didn't want to talk about something, did he avail himself of the opportunity to go and discuss it with his counsel?
The last time...
Objection, Your Honor. May we approach?
Yeah.
Sure.
So it's, again, it's based on my training. I don't ask questions that might get somebody in trouble, for example. So I don't do that. And if somebody doesn't want to talk about suicidal ideation or drug history, it depends on whether that was important at the time of the offense. I can let it go. Sometimes I'll revisit it in case the person has a change of heart and may want to talk about it more. In some cases, when the refusal has to do with the mental state at the time of an offense, that's an important subject matter to cover. And so in that case, then I will ask the person to reconsider, which I did in this case. And then with further resistance, then I would suggest perhaps you might want to talk with your attorney.
Objection, Your Honor.
And then that's it.
Overruled.
And then I let it go with that. And if they decide not to talk about it, then at least I've given them, the option to talk with counsel.
All right. So let's talk about the fact, what is contained in your report. Can you just give us a brief synopsis of not the details, but sort of the sections and how that report is set up, so if the jury wants to read through that report, they can do that.
So the way my report is arranged is I list the medical records first, and then I'll list a synopsis of my opinions. Okay? When you see the history section, that's based on the records that I reviewed. So there are no opinions or analysis in there. And then within that section, I will add the interview, because that's also part of the history. And then after that, then I go on to the discussion section, and that's where I repeat some of the findings in the history section, arrange them according to diagnoses that I've arrived at based on the records and his self-report. And then also my analysis of what's going on and how it relates to the offense, if at all. And then that's about it.
All right, so let's talk about your findings in this case. What opinions did you render as a result of your evaluation?
There's actually a typo here. There are 6. The first is he had a childhood history of abuse. That was in the records.
Okay, hold on. So childhood history of abuse, what abuse are you talking about?
Abuse I used in a larger term. His growing up with his mother, no offense to his mom, was not so stable. So there was some abuse in the form of neglect, things like that. Her and her husband at the time were argumentative, likely domestic violence, what I remember at the records, those kind of things.
Okay. But as far as him being abused, other than this episode that's the sexual abuse that's been alleged, did you have any other specific incidents of him being abused during his childhood?
Just the abuse and neglect predominantly by his mom, and then the sexual abuse incident when he was around 10.
Okay. So with regard to him being involved in abusing other individuals, were you here for the testimony here, previous witness in this case?
Yes.
And is that consistent with other statements in the medical records related to his abuse of his brother as well?
Objection, Your Honor. May we approach?
There was a history of him having mixed symptoms of anxiety and depression.
Okay. And I think at some point you talked about possible PTSD symptoms, is that right?
Right.
And do you know whether or not he's been diagnosed with PTSD?
Based on the expert reports that I reviewed after I submitted my report, some of the experts arrived at a diagnosis of PTSD, some did not. Prior to my report, no, there was no diagnosis per se of PTSD.
So if you have an expert that said he tested him and he did not have PTSD, would that surprise you?
No.
Now, the next finding with regard to your report, what was that?
History of autism spectrum disorder, ASD.
And there's been a whole lot of testimony related to that. I don't want to go back into that specifically, but one of the things that is that you see with regard to autism spectrum disorder is resistance to change. Is that right? How would you say that?
That's one example, yes, sir.
Okay. Did you call it something called the quarter of sameness?
Yes.
Okay, can you explain that real quick?
For some individuals, not all, but it depends. They like everything the same. It's consistent. They repeat behaviors. That's one of the criteria over and over, like along with that sameness. And then there's a rigidity. In other words, things have to be the same or people become upset. Not everyone, but some people who have ASD.
Now, have you looked at you said that you reviewed the videos in this case, is that right?
Yes, sir.
With regard to the FedEx videos, were there multiple days which he was driving that were provided to you?
Yes.
Okay. With regard to the day of the offense itself, did you go over that thoroughly in conjunction with the transcript provided to you as well?
Yes, a few times.
And were you able to look at that transcript to determine whether or not what was said on those transcripts is things that you actually heard yourself on that?
I did hear them, yes.
Okay. And so with regard to what occurred in the particular video on the day, what we'll call the abduction video, did you see his ability to adapt to change based upon changing circumstances?
Yes.
Okay, can you kind of explain that to the jury, what you saw?
So after he initially abducted her and was not talking much with her, then he started asking her questions about her family, school, things like that. And it, at least by my observation, Athena seemed more calm by that. So that was an ability on his part to understand the situation, what was going on, and change his approach, as opposed to just picking her up and throwing her in the back of the truck. So that was something that I caught. And then under that immense stress of having started that crime, he was persistent in in his activities with her, basically.
And after the crime was committed and the body was disposed of, did you see his ability to change again?
Yes, as far as not being detected, covering up what he did, those kind of things, yes.
So were those things consistent with autism spectrum disorder or something else?
It was not consistent with somebody who wanted sameness, for example, or couldn't problem solve under that kind of stress. And again, my presumption, and he said it was stressful, that taking the life of a human being is stressful. Okay? So I didn't see him struggling with those kind of issues of lack of problem solving. He was still trying to go undetected.
Now, the next diagnosis, I believe, was a history of ADHD. Is that right?
Yes, sir.
And with regard to the defendant's level of ADHD, was there anything debilitating about that with regard to him in this case?
Debilitating in the sense that he was socially a bit awkward, but that crosses over with ASD. So what I mean by that is kids who have ADHD, it's not unusual for them to be impatient and they kind of cut line, or somebody's talking and they interrupt, those kind of things. They might get on somebody's nerves because they're just throw themselves in. But as far grade-wise, he did actually pretty good. I looked at his transcripts. His IQ was average, so no intellectual deficits as a result of ADHD. But he was taking medicine, and it seemed like it was working to some degree as long as he took it.
So then the next thing that you say is a history of personality pathology.
Right.
And can you explain what that means to the jury?
Personality pathology is a broad term used to describe somebody who has had trouble interacting with others, basically.
All right. And are there different types of personality pathology?
Yes, sir.
And can you kind of tell the jury about that?
There are many. I'm not going to be long-winded here.
I don't want you to list every possibility, but are there some specific ones that you believe apply in this case?
So there's cluster A, which are the odd personality types. Yes, he has some of those, but he also has ASD. So per my training, I check the boxes on both and leave the doors open to see actually what happens with it. He's gotten into trouble here and there. He has really big issues with his temper. He's always had that, been physically destructive. So clearly there were issues with antisocial personality pathology, and again with ASD, because he has issues with controlling his temper, impulsivity, those kind of things. So I checked both of those boxes. He was sensitive to abandonment. Those were, if you remember, he attempted suicide after his girlfriend left him, and that's not unusual when somebody's overly sensitive to abandonment. I'm not minimizing what he was struggling with at the time, and that falls under a type of personality pathology called borderline. People with borderline pathology also have issues with anger management. They can't control themselves, and their relationships tend to be very unstable. A lot of arguing, instability, those kind of things. So there are many things that showed up in the history and in the records that I reviewed that I was checking both boxes. Some were ASD, and some were also personality pathology.
And did you also mention something called narcissistic personality?
Yes. Yes. To some degree. In other words, he had, no offense to him, sometimes maybe an exaggerated opinion of himself, how popular he was, things like that. But not much more than that.
Now, your last finding, I think, is sort of the ultimate finding regarding the guilt portion of the case.
Right.
And what was that?
Basically, as a result of looking at all of his history, he did not have a severe mental disease or defect, and therefore he would know that his conduct was wrong. In other words, he was not insane.
So, what experience do you have with dealing with sex offenders, and specifically sexually violent offenders or predators?
In a nutshell, a lot.
Can you just kind of briefly tell the jury?
I'll keep it brief. So in my fellowship training is where I obtained my experience in evaluating and treating people who had sexual deviants / sex offenders. And that was in Chicago during my fellowship. And then when I returned home to Texas, our state enacted a commitment statute for sexually violent predators, which were the most dangerous repeat sex offenders who were about to be released from prison. And so we had hearings to commit them to treatment. And I've been involved with the state in those hearings for probably the last 25 years or so, hundreds of cases. That's why I said a lot.
You talk about in your report something called sexual deviance. Can you talk about that related to the defendant?
Okay, so sexual deviance in a broad term is an old classic medical term, and it basically correlates with a term you probably may have heard in this trial called paraphilia. And sexual deviance is basically when somebody has abnormal or pathologic sexual interests. And it largely has to do with individuals who don't give consent, so that's primarily children, adolescents, underage, and women who are sexually assaulted against their will. Or maybe somebody flashes somebody on a corner and the people around they didn't consent to that. So again, consent issues. There are less of a subset where if somebody is overdoing it in sexual activities that interfere with what they're doing the rest of their days, then that could fall under sexual deviance also.
All right, so talking about the evidence and the facts in this case, specifically related to the assault or kidnapping, sexual assault, torture, and murder of Athena Strand, do you see evidences of sexual deviance on the part of the defendant?
Yes.
Can you explain that for the jury?
So when I reviewed the audio recording, it was very clear to me that he abducted her primarily for sex. Because soon after he drove to the secluded spot that he had picked out, that's when he started engaging in sex with Athena. It's basically oral sex. He was teaching her how to do it, telling her what to do, threatening her, those kind of things. The things that I heard in audio recordings of victims in these cases, read about in investigative reviews of the victims in sexually violent predator hearings, all the same thing. So that's what stood out to me. So that's interest in sexual excitement with children is abnormal. And then the amount of suffering that Athena went through while he was victimizing her, that has some features of sadism. Sadism is where somebody either physically harms somebody or emotionally harms somebody, and it's part of the sexual experience. So there were two areas that caught me looking through that interview and then correlating it with the transcript.
Now, were there other things other than just the facts of this case that indicated paraphilic features to you? As far as more than just the other evidence in this case, besides the kidnapping and murder?
So, to answer your question, interest, abnormal or pathologic sexual interest, they don't just show up all of a sudden like with kids. It's been brewing for some time. So I already knew that something had been going on. I didn't know why it was quiet, but something was going on, and that incident with Athena, it emerged. So that's the only thing I would add with that.
Well, you've also reviewed reports regarding the Tarrant County victims.
Oh, yes, I forgot about those, yes.
And also you heard the testimony just previous to yours. How does that influence you in those areas?
So, let's see. So those are, in other words, when there are other victims involved, and these are alleged victims, by the way, so these are not convictions. That raises, for me, sexual versatility. So there are numerous outlets for sexual activity that are, and also, involving his wife and other women at the same time. So he has both features, but it's clearly versatility and increased sexual activity. Let's just call it that way. That's what drives the exploration and the versatility.
Can you look at page 4? Do you have your report in front of you?
I do.
Can you read it's the third, page 4, and it's the 1, 2, 3, 4, 5th full paragraph. And it starts about the third sentence down where it says, he acknowledged the prior history of. And if you will continue that through the end of that paragraph. You see what I'm talking about?
Oh, is that the first paragraph, Mr. Horner denied any history?
Yes.
Okay.
So, but just, I'm not worried about what he denied.
Okay.
I'm more worried about what he admitted to. So if you would start with, he acknowledged the prior history.
Okay. He acknowledged a prior history of sadomasochism and asphyxia, that's basically choking during sex, due to other women who encouraged him to participate.
Okay, so he's saying that he has been involved in, what is sadomasochism?
That's where the use of pain, the introduction of pain and humiliation into sexual activity for some individuals heightens sexual gratification. So spanking, hot wax, sometimes people use needles. Let's see, in his case, he reported inflicting cigarette burns during sex. So clearly, the experience of pain gets mixed in with sexual pleasure.
And then he also talked about asphyxia. What is asphyxia?
It's choking.
And you understand that he pled guilty to strangling and Athena and asphyxiating her.
Yes.
A person that does this in a sexual manner, do they normally do that to cause death?
In a normal manner?
No. If a person is doing these in a legal manner.
In a normal manner, or legal manner, asphyxia does heighten sexual pleasure. Let's put it that way. As long as you can keep the person, in other words, you don't knock them out.
So,
I'm not encouraging anyone to do that, but that's basically it in a nutshell.
okay, so he admitted to you that he had used choking during sex in the past, is that right?
Yes.
Okay. Now, with regard to other sexual behaviors, did you listen to the testimony outside the presence of the jury of the previous hearing of his former girlfriend and mother of his child?
Yes.
And what, if any, testimony that she gave influenced you in this area?
What was added, listening to that, reading the testimony that was different in the records, or in other words, added to the records, was she just...
Your Honor, I will object to hearsay.
Overruled. Go ahead.
Okay, I already knew about the issue of dominance. He liked to dominate her, he was rough. She had to set limits at times, but she consented to it until she said stop, and then he did. There was some role-playing involved as well. What they did participate in is him playing as if he was her father, her daddy, and she was his little girl or princess. And so they used to role-play like that as part of their sexual activity. There were ropes. She was not too excited about that and didn't want to participate. He had talked with her about hog tying her. She said no, those kind of things. So clearly he has an interest in things, but he abided by her refusals and didn't go further, but the interest was still there.
Now, with regard to the way that he talks to her on the video related to this idea of sadism, can you explain your opinions related to the things that were said by the defendant to Athena Strand during the time, between the time that he kidnapped her and the time that he ultimately killed her?
So what I heard were statements, were threats. If you scream or if you say anything, I will hurt you. Later is I will kill you. He often called her bitch when she came to, so to say. He was clearly very angry about that. I remember a comment, what part of shut up, don't you get, bitch, those kind of things. So very degrading towards her after he had nearly beat her and strangled her to death.
Even as she is dying, does he make a statement to her about whether she's given up?
Right. Yes.
You
Like she didn't know when to give up.
Talk about Tanner's reasons. Did he explain to you his reasons for covering the front-facing camera during the interview?
With me, yes.
What did he say to you?
It was basically to cover up his drug use during work.
Now, since you have reviewed the videos, were there times where he was actively preparing and then smoking marijuana on those videos?
Using a vape, yes.
I'm sorry.
A vape pen, yes.
And, but did you ever see any evidence of any type of cocaine use at all?
No.
With regard to premeditation, do you have an opinion about whether or not this was a premeditated act, not necessarily with regard to Athena herself, but with regard to a child on that day?
Based on the evidence, yes, I can answer that.
We object. May we approach?
Dr. Arambula, you can answer the question as far
Okay.
as, other than just covering the front-facing videos, what other evidence did you review that makes you feel that this could have been a premeditated act?
All right, so the word I use is planning, and that's what I'm looking for in my fellowship training. I remember in the investigative records that he'd gone to the site before he took Athena to the site, and that made sense because in the audio he's telling her, okay, it's going to get a little bumpy now, so he knew where he was going. I asked him about why did you stop at that spot. He said it was secluded, so he obviously selected that. I talked about grooming earlier, when he changed how he was talking with her to help her calm down, to gain her trust, so to say, cooperation. That's what people who have some sexual deviance do to their victims before they exploit them. That's part of the planning as well. And then obviously walking her through what to do, how to do it, not to yell. That's all part of planning, okay, according to what he's thinking.
First thing that you said he visited the site. What site are you talking about?
The site where he stopped the FedEx truck, basically.
Where he turned off the engine
Yes, sir.
and sexually assaulted Athena Strand?
Yes.
He had visited that site previously to that?
That's what I recall in the records, yeah.
And with regard to his, does the fact that planning engaged in this and preparation, does that make it different from somebody that is just overreacting to something that happens in spurs of the moment?
Yes.
In what way?
So again, this per my training in evaluating individuals who are commit sexual offenses, most of the time there's planning involved, as opposed to somebody just attacks somebody out of a bush. Okay, that's very impulsive, and that's a very different type of sex offender. Probably more, there's other things going on with that individual. So I'm trained to look for whether planning is present, grooming, those kind of things. That's why listening to the audio visual of the abduction made sense to me, that it was planned.
So I want to ask you ultimately, because your findings are laid out in your report, but the one finding that you were not asked to make has to do with the special issues for punishment in this case. Do you have an opinion as whether or not the defendant, that there is a probability of the defendant committing criminal acts of violence in the future that would constitute a continuing threat to society?
Yes.
And can you explain what that opinion is?
Yes, based on the evidence that I've reviewed, it's my opinion that there's a probability Mr. Horner will commit future acts of violence and pose a continuing threat to society.
And is that true whether or not he is incarcerated for the remainder of his life?
Correct.
And can you explain that?
Okay, so not to rehash everything, but I'll just succinctly say he's had issues with controlling himself pretty much all his life for a number of reasons. That got worse as he got older. It culminated in this. Other experts have said he has issues with executive dysfunction, controlling his anger, emotional regulation, and impulsivity. That's all involved in this. So whether he's in prison, I've been in prison quite a number of times just to visit and interview people. It's like a little society, all right? So it doesn't really matter the setting, because he's going to come across in prison more or less people that he would probably come across in society. Because he has a mental health issue history, he's going to go to the clinics. There are techs there. They're almost, at least for me, my experience, most of them are females, techs, nurse practitioners, therapists, and there are female guards, of course. So it's a replica of our community, but it differs, obviously. The type of people that live there are also very aggressive, threatening. It's stressful, at least from the people I've talked to.
Now, I want to talk to you about incidents specific to you. You said that when you did your interview with the defendant, it was you, the defendant, and 3 guards in this room, correct?
Yes, sir.
Can you explain the situation that happened with regard to when you were questioning the defendant related to whether or not he sexually assaulted Athena Presley Monroe Strand?
Okay. So that was towards the end of the interview, and we'd taken some breaks because he didn't want to answer questions, and that's okay. But he was becoming a little bit more worked up, and this last question, I was looking at the transcript, and he was kind of critiquing me that transcript was the DA had made up, and it had inaccuracies and blah, 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 and he didn't do anything to Athena, et cetera, et cetera. And then I responded to him, I heard everything you told her. And it just stopped him. He was very upset. His stare went right through me. It took me aback because I wasn't expecting that. And then the rest of the interview, I didn't challenge him after that because I could sense his anger.
Was it incongruous with what you had up until that point?
Yeah, as I said, there was some increasing irritability when he refused to talk about certain subjects, and then he would come back and say, I needed a break. That's fine, I understand that. But this one was different. I was not expecting that type of anger from him.
Pass the witness.
Cross-examination.
Oh, yes. Dr. Arambula, we had a hearing back in December to discuss your review of the records and your opinions in this case. Is that correct?
Right.
And at that time, you had not evaluated Tanner Horner. So
Right.
you really didn't have a lot of opinions on that day, did you?
Right.
You had the opportunity to review all the records in this case, is that right?
Yes.
The records you reviewed, and I imagine you did a thorough review of the records, right?
Yes. I mean, let me add, there were a lot of Facebook posts, and some of them may have been years ago, and so I just kind of scanned them, for example.
So,
But I looked at them all. I just didn't spend a lot of time on some compared to others.
So you scrolled through all 10,000 pages of the Facebook records?
I didn't have 10,000 pages. I didn't count the Facebook posts, so I don't know how many there were.
Are these posts that were provided to you from the state?
Yes.
So they didn't provide you the entire 10,000 pages of the Facebook records?
I don't recall that there were 10,000 pages of Facebook posts. No.
So the state only provided you the posts that they wanted you to see?
No, not necessarily, because when I'm going through the hard drive, portable hard drive, there may be some elements in the history that I print. I'm old-fashioned and I print stuff. And then other pages that I'm not going to print. And I decide that by looking at it. And so if it's just social commentary, things like that, I'm probably not going to print it.
All right, so you also did a thorough review of all the medical records in this case.
Yes.
And the records that you reviewed, I think you said were listed on your report.
Yes, ma'am.
So you looked at his mental health records.
I did.
You looked at his physical health records.
Yes.
You looked at the records from the sheriff's office in Wise County.
Investigative records, yes, ma'am.
And those investigative records, would that be the records related to the suicide attempt?
You mean the one in the jail? Or?
Yes.
Yes, I saw those records also.
So when we were here back in December, you hadn't evaluated him and you hadn't reviewed all the records. We had another hearing back in April of this year. Do you remember that?
Yes, ma'am.
And we asked you a lot of questions about the records you reviewed and about your opinions in the case. And you didn't update your report with any new opinions, did you?
I did not.
Did not issue any supplemental report.
Correct.
And you had over 4 weeks to do that.
Before the hearing, you mean?
From the hearing until now.
That's correct.
But you did amend it because you had some typos in there, right?
Yes.
And we're not going to hold those against you. We all
Okay.
do it. But you had the ability to amend your report.
To add to it, yes, covering the sentencing issues, yes, I could have done that at best. Yes.
So you talked about the sources that you used, and I don't see a new list of records that you reviewed on your report.
Correct, because I hadn't received that list yet.
So you mentioned nothing in your report about deposition or the prior testimony of the mother of Tanner's child.
That's actually in the investigative records. I don't remember which law enforcement agency it was, but it was in that.
All right, so when you look at collateral sources, you would agree with me that collateral sources are an important source of information.
They typically are, it just depends.
And if there is an issue with inconsistency or inconclusions or poor historian, just with the person that you're evaluating, if it shows that they are a poor historian, isn't it important to go back and look at collateral sources to try to, either shore up what they're saying or disprove what they're saying?
In the instance where somebody doesn't remember something, then collateral information fills in the hole. If somebody misreports something or they exaggerate it or deny it, then if I obtain collateral information that, let's say, is hypothetically correct, I don't disregard what was told to me initially. In other words, they all coexist.
So let me ask you this. As a forensic psychiatrist, you typically don't administer any testing, do you?
That's correct.
But you do rely upon the reports of people who did administer the testing.
Yes, I do.
And you reviewed all of the reports from our doctors,
I did.
all the reports from our experts, and you had the complete file of the DA. Did you review all 40 hours of the video that was provided to you?
Probably.
How much do you charge an hour?
$3.50 an hour.
So if your bill is $28,400 divided by 350, that's about 81 hours you've put into this case so far?
Up to the time of the billing. I think the last bill was April, so it wouldn't include whatever I've done getting ready for this trial. And
Okay. Go ahead.
I didn't review your experts, which took some time to read also.
So half the time that you spent preparing for this trial was watching the videos?
Most of it, yes, because like you said, it was close to 30, 40 hours, so that was a long time. The records, no offense, some of them become redundant because they're different agencies and they're all there. And so I don't spend as much time when it's telling me that basically the record is telling me the same thing.
When you found out that Tanner had entered a plea of guilty in this case, that changed the focus of your testimony, is that correct?
I thought it would change the focus, yes, ma'am.
So your original focus, it appears, was to determine whether or not he was insane at the time of the commission of the offense.
Essentially that, or what mental state issues were at the time of the offense.
Are you familiar with the laws regarding the insanity defense in Texas?
I remember the basic verbiage.
So are you aware that in order to present such a defense, the defense would actually have to give the state notice that that was their intent?
That's been my experience. I'm not a lawyer, but it's been my experience, yes.
So in this particular case, to your knowledge, did the defense give the state notice that they were going to use the insanity defense? Or that we were going to use the insanity defense?
I did not know at the time, but again, this is guilt-innocence phase, and so that would infer to me that it could be insanity or something that affected specific intent. I didn't think that was involved in this type of case, but largely just mental health. I followed the judge's order looking at his mental health condition, and that's what I did.
Well, didn't you talk to the state before you came in for the interview and the evaluation?
Just where to meet, that's basically it.
So earlier you testified that Mr. Berry went to San Antonio to meet with you in your office about the case.
Right, I thought you meant a meeting before the evaluation of Mr. Horner, but no, I didn't talk with them about what I was going to do. It's just logistics, like what time, where do I go, those kind of things.
Okay.
The meeting, yes, that's when they retained me.
Okay, so that's what I'm getting at. So at the meeting where you were retained, they talked to you about what they wanted from you in this case?
As far as just looking at the records and providing my psychiatric analysis, that's it.
And that discussion took place in 2023, or when did that discussion take place?
February of 2023.
So from February of 2023.
Actually, I take it back. It was probably January of 23.
Okay. So from January of 2023 to February of 2026, you did not have any discussions with the prosecutors about this case and the direction it was going?
No, I met with them another time to go over my findings initially. I hadn't looked at the videos yet because that's a lot of time, and so they knew that. And basically, I was just looking at his mental health condition. I hadn't received the order yet, so I didn't know what the parameters were going to be.
Let's talk about the paraphilic disorders. Sexual deviance is not a diagnosis in the DSM-5, is it?
No.
You just use that for your testimony?
I use
because
it
of the historical significance of it?
Right, because of historically that's been the term. The DSM is not the Bible, so to say. So if they switch it, that's fine. If you look up like literature searches, etc., loads of research regarding sexual deviance, very limited regarding paraphilia, as an example.
However, you would agree with me that the DSM-5 is a diagnostic tool for mental health evaluations.
Yes, it is.
And that sexual deviance does not appear as a diagnosis in the DSM-5.
It does not, no.
Would you agree with me that most of the people that have an atypical sexual interest do not have a mental disorder?
That do have or do not have?
Do not have a mental disorder?
If they have an atypical sexual interest or if they don't have one?
You would.
I lost you, sorry.
Do most people with an atypical sexual interest have a mental disorder as well?
I can't say I've seen a lot of research on that because it's pretty vague, no offense, and gray. But that could be fair. I would say that, at least from my experience seeing patients, there's typically something involved, but it's not major, so to say. It's just maybe something that happened in their history such that it has some segue to what they are doing as an adult.
Okay, so we'll go back to the original question. You would agree with me that most people with an atypical sexual interest do not have a mental disorder?
I think that, again, there's not much research on it, but per my experience, I think that's fair to say they don't have a major mental disorder.
Because in order to have a paraphilic disorder, the diagnosis would require that person feel personal distress about their interest and not merely distress from society's disapproval.
That sounds like one of the criteria, right?
And in order to have a diagnosis, that it would require non-consensual engagement.
That's what I talked about, yes.
And so if someone is consensual and engages in these activities, that doesn't qualify as a paraphilic disorder, does it?
I agree.
You specifically mentioned that the interview and the testimony of Tanner's, or the mother of Tanner's children. Isn't it true that she consented to the behavior that you described?
I remember reading that, yes.
And when she became uncomfortable with anything, she took the initiative and she withdrew that consent, didn't she?
Yes, I spoke about that earlier.
And when that consent was withdrawn, Tanner stopped what he was doing.
Yes, same answer.
So he didn't continue against her will, did he?
No.
You mentioned sexual sadism in your direct examination, and you would agree with me that sexual sadism wasn't included in your report, was it, as a diagnosis?
I did not diagnose Tanner with pedophilia or sexual sadism.
And the reason that you did not diagnose it, I believe you had said that there was no diagnosis because of the one-time occurrence.
Correct.
Now, you're talking about the sexual sadism, and you're basing it solely on this offense. You said that you had talked about, the distress that you heard on the video.
So the video was probably the primary source, but it was not sole or by itself. There was other pertinent information. Why I talked about that earlier.
Well, there was no collateral evidence of sexual sadism, is there?
No, I didn't. I'm not referring to that. I'm referring to what's in the literature, and again, per my training in this subject matter.
Okay, so I'm going back to this case, not what's in the literature, but in this case, you were basing your decision and your opinion on the sexual sadism on something you could not see.
So one thing is, there are features of sadism, and it was something I did not see because he covered the lens, but I heard it.
And at the end of the day, again, you didn't diagnose Tanner with any sort of sexual sadism.
Correct.
You also did not diagnose Tanner with any sort of paraphilic disorder, did you?
Correct.
Because it did meet the criteria in the DSM.
Right.
You commented that things like this just don't show up.
Right.
So it sounds to me that you're basing your opinion on if he did it once, he must have done it at some other time, without any evidence-based criteria there.
No, not using your verbiage, no.
So let me ask you this. You reviewed all the records, you looked at all the evidentiary, what's the word? Investigative, I'm sorry.
Okay.
Investigative records from the district attorney, from the Texas Rangers, from the FBI, from Wise County Sheriff's Department, and any of the records that you reviewed, you didn't find any evidence of child pornography on any of his devices, did you?
That's correct.
And the things that you spoke about, the spanking, the hot wax, the needles, none of that's illegal, is it?
As long as the both involved consent to it.
You mentioned threesomes. That's not illegal, is it?
No. As long as there's consent between the three.
Asphyxia during sex. That's not illegal, is it? If there's consent?
Correct.
Role playing. That's not illegal, is it?
With consent, no. The same thing.
And you'd agree with me that it's not uncommon for couples to have pet names for each other?
No, it's not.
And so if I call my boyfriend baby, that doesn't necessarily mean I think he's a child in diapers, does it?
I hope not. No.
I hope not either. You also did not diagnose Tanner as a sexually violent predator, did you?
I did not.
Now, when you did talk to Tanner about what happened, about this offense, and about what was going on in his life leading up to this, you talked to him about the troubles that he had at home, didn't you?
Yes.
And he discussed with you that he was working long hours and that he was working 6 days a week?
Yes, we covered basically what his work days were like and what he had to do in preparation for each day, each route. Yes.
So we talked about the stress of not having reliable transportation and the change in his work route and things of that nature.
Yes, ma'am.
And he also told you that he covered the lens of the camera in the truck to hide his drug use.
Yes.
When the state asked you that, whether or not you saw any cocaine use in any of these videos, you said, no, I didn't. Well, let me ask you this. Is it possible that the cocaine use occurred after Tanner had covered the lens with the sticky?
That's what he said in the evaluation to me.
So you said you didn't see it, but is it possible that that's when it occurred?
Sure, like I said, that's when, in other words, I'm answering you using his self-report.
With regard to the planning of this, Tanner had been on that road before with his truck. Do you recall that?
Yes.
So it's not that, when you said that he had been there before, the way that it came out is that he went there to scout the place as a place to bring a victim. But that's not what was going on, was it? He had actually been there because that was the route that FedEx had sent him on to deliver packages.
I'm going to check that for that, Your Honor, it's a mistake.
I'll let him answer it if he can.
Well, he had been on those routes before, but I remember from the investigative records that before he abducted Athena, that he spent some time at that place where he drove back to.
What
So
records?
yes to both.
So what records are those?
There were some. It looked to me like FBI records where they were charting his movements based on cell phone pings and towers. It's way over my head.
Did you think to try to find collateral evidence that that may have been just his basic route? Or did you just take it at face value and make the assumption that that's why he had stopped there?
I just know that he stopped there before, and like I said before, he told me he had been on those routes before. So either way, he knew when to tell Athena it's going to get bumpy, because he had been there.
But that's not necessarily indicative of planning, is it?
Well, he knows where he's going. In other words, if he didn't know where he was going and it was just impulsive and he had no idea where he was, then he wouldn't know to forewarn her that it's going to get bumpy.
But again, that is not indicative of planning to abduct a child, is it?
Yeah, I looked at it as part of the abduction. As I stated earlier, the abduction was related to his sexual exploitation of her. That was very clear to me. And how he got there was just how he got there, to where it was going to happen.
And that is just your opinion as to why this happened.
It's based on, well, it's not just my opinion, it's based on my training, the grooming behavior that he engaged with her. You heard the audio as soon as he turned off the truck, he went to the back, then take off your clothes, and then from there, it was one after another.
May I approach, Your Honor?
Yes.
Dr. Arambula, I'm going to hand you what's been marked as State's Exhibit 312. It's your report. Can you point out in your report where you talk about going on the bumpy road and planning this incident?
I don't remember actually doing that, no.
Okay, can you point out in your report where you talk about grooming?
I think the only thing I talked about was that this event didn't just show up out of nowhere. Again, this is during the guilt-innocence phase, so it's different than what we're talking about today.
So planning would not be a part of the guilt-innocence phase?
If it relates to the mental condition that he had and he was claiming confusion, then that would counter it, but that's not what he was claiming, so I didn't include it in my report.
So grooming wouldn't be relevant enough to include in your report?
I mean, I could have added that, sure.
But you chose not to.
Well, maybe I didn't just do it. But yeah, looking at the.
Your Honor,
Okay.
non-responsive.
Sustain.
All right.
I want to talk to you lastly about your opinion on future danger. You claim that you feel that Tanner will be a danger in prison because there are female guards.
Not
That's part of it.
as a potential component, yes.
So you review the records and you realize that, and you understand that Tanner has not had any disciplinary write-ups in Tarrant County.
I think, yes, that's correct. In his solo cell, he has not been a behavior problem.
And he did not have any disciplinary write-ups in Wise County either, did he?
I think there was only one time where he was put in a restraint chair that he pointed out to me, but other than that, no.
And he was put in a restraint chair because he was inflicting self-harm.
I
Is that
think
your recollection of it?
Vaguely. I don't remember the reason that he explained to me.
So that wasn't really a disciplinary, was it?
It's a form of disciplinary because the people can't just let him do what he's going to do, so they have to discipline him in some way so he won't hurt himself.
But he
It's not a form of discipline. It's more of behavior modification.
So he wasn't being aggressive towards anyone when that occurred, was he?
I don't remember that. No.
Now, when you're in a jail, you don't eat in your, you don't stay in your cell 24/7, do you?
Yeah. You mean if somebody's in general pop?
Let's say you're in SAG. You don't stay in your cell 24/7, do you?
No, there's some time out where a person is allowed outside. I think it may be an hour, maybe more, but I'm not the expert about jail stuff.
Okay, so, but you know that there are female guards in prison, right?
And jails, yes.
So you have guards in jail, you have guards in prison, you have access to medical unit, access to the transport people,
Right.
access to,
Your Honor, I'm going to check defense counsel testifying, first of all, and secondly, what the purpose of her being out there.
about to enter some records, Your Honor.
I'm assuming you were going to show him a record.
Yes.
Go ahead.
So, how many people in Wise County did Tanner attack?
I don't recall seeing any records of that, no.
How many people in Tarrant County has Tanner attacked?
Same reason. He's been in a solo cell and no acting out.
So you say he's been in a solo cell, but you do know that he has been going to the doctor,
Yes,
that he's been coming to court,
correct?
that in court you had other people with you in court. He didn't try to attack any of you.
No, he didn't attack me. He was just angry with me.
Your Honor, I'm going to offer defendant's exhibit number 93, which has already been tendered to, we just never offered it in
No objection.
Defense Exhibit 93 has been,
And Your Honor, to publish to the jury.
That's fine.
And it requires, this is kind of on the evidence. I think they need the records.
oh, you can file records with the court if there's what we call a business custodian gives an affidavit saying basically these are authentic records of our department, our business, or whatever. That's why they're called business records. And they are admissible without a sponsoring witness testifying. So you may accept what is contained in the records in the same manner had somebody been here to testify to them. Okay? Go ahead.
And may I explain what the affidavit
Yes.
means? Okay. What this affidavit is an affidavit of no records from Tarrant County, meaning that they searched their records and they could not find any record of any disciplinary action in Tarrant County. When people are in custody, Dr. Arambula, I believe you said that they had access to tablets. Was that you that testified to that? Or was
No.
that Mr. Fitzpatrick?
Yeah, that was the TDCJ
Okay, I'm
guy.
sorry. But you've been in the prisons, you've been in the jails before, is that right?
Yes,
So, you know, in talking to inmates, they just don't have to sit in their cells 24/7, do they?
unless they're in solitary for some reason. Yeah, and again, they get out, I think an hour a day. But otherwise, no, they can roam around.
So in their cells, do they have access to educational materials?
In jails, I haven't seen that as much. In prisons, depends on the unit.
As a part of the educational materials, or I should say as a part of what they can do in jail. And as I said, they have access to the educational materials. They can also do things like Bible study.
So that my answers are based on what information I've learned from other people who are inmates, because I have no idea who makes how TDCJ administration decides. I've just heard things from individuals. But yes, you're correct. There are some people who can, some cannot.
May I approach, Your Honor?
Yes.
Dr. Arambula, I am going to show you what has been marked as defendant's exhibit number 95, and we move to admit, I'll just go to 94 and 95, which have been previously tendered.
No objection.
So are there two exhibits, 94 and 95?
94 and 95, Your Honor.
Okay, no objection to either one.
Correct.
All right, defense exhibit 94 and 95 are admitted.
And Dr. Arambula, you just made the comment that some can and some can't do things in jail. In looking at defense exhibit number 95, are there a lot of certificates there for the things that Tanner did complete in jail?
It looks that way, yes.
And Your Honor, may I publish to the jury?
Yes.
All right, Your Honor, I'll pass the witness.
Redirect.
No further questions, Your Honor.
May Dr. Arambula be excused.
No objections.
He may be excused?
Yes, Your Honor.
Okay, thank you, doctor.
Just give us a...
State rest is revoked. Sanderson,
Defense rests.
state rest and close. State does. Defense rest and close.
Yes, Your Honor.
Okay. All right. There are a number of you who have not seen the last few exhibits, okay? What I'm gonna do is I'm gonna send you to your jury room with those exhibits so that y'all have a chance to look at them. And everyone is finished, buzz. This will include all of the evidence that you're gonna hear in the case. You know what your instructions are for in the morning, okay? And we will get started promptly in the morning. So after everybody finishes looking at the last two exhibits, it'll be regular time, 9 o'clock. Finish looking at the exhibits, buzz, we'll bring those out, and then we'll get you home, okay? See you in the morning. All right, everyone may be seated. Both sides having rested and closed. Ms. Anderson, it's my understanding the defense wished to make some motions.
Yes, Your Honor. One was related to the jury charge.
Okay, we'll talk about that in just a minute.
Okay. The other one is related to our motion to preclude the death penalty because of the autism. When we initially argued the motion, I had put all my arguments on the record, and we had held it to determine whether or not there were any valid diagnoses for autism. And so at this time, we would re-urge the motion and ask the judge to take judicial notice of all of the evidence that was presented by the defense witnesses related to the diagnosis of autism.
I'll take judicial notice as requested, and any other requests?
No.
Okay, those are denied. Now, that's the only other motion other than dealing with the jury charge.
I believe so. You're asking me as if I should have another one, but.
Just making sure. All right, let's talk about the jury charges. I have furnished charges proposed charges ad nauseam to everybody. The court's intention is to have two separate charges, one dealing with the issue of guilt, and then the second one regarding the issue of punishment. Is that agreeable with the state?
Yes, Your Honor.
That's agreeable with the defense.
Yes, Your
All
Honor.
right, in regard to the guilt charge, are there any objections or specially requested charges on behalf of the state?
No, Your Honor.
Defense?
No, sir.
Okay. All right. The punishment charge. State have any objections or specially requested charges to the punishment charge as proposed?
No.
Defense?
Your Honor, we don't have any special charges. However, we do have a form issue rather than content. And that is, we wanted to move the verdict forms to, the verdict form on special issue number 1 to page number 3. And insert that and let the jury have the law related to special issue number 1, and then answer special issue number 1 before they move on to the law on special issue number 2. And then we would ask that the verdict form on special issue number 2 be moved to right behind that. And that we move all of the instructions to prior to special issue number 1. Did that make sense?
It does.
Okay.
The record should reflect that counsel, for both sides, have been very forthcoming with me in regard to their requests, and it's my understanding that that's why they do it in federal court.
That is correct, Your Honor.
But I am going to deny your request. Okay? Finally, it's my understanding, having had a conversation with the lawyers, that 1 hour for closing arguments on both sides is agreeable. Is that correct?
Yes.
Mr. State said he'll leave 20 minutes, that's all.
And before we break, may we approach?
Yes. Have a warning in regard to the open.
Yes.
Okay. How much time that you have used?
Yes.
Okay. What's the amount
When I get to 25,
that you have used? 25 minutes.
yes.
Okay. Mr. Goble, it's my understanding you're going to open for the defense.
Yes, I'll begin, Ms. Anderson also, so if I can have a 25-minute warning, that'd be great.
That you've used 25 minutes.
Yes.
All right. And Ms. Anderson, do you wish to have a warning as far as time remaining?
Time remaining, if I have 30 minutes remaining, then that'll be my warning. No, actually, I need 5 minutes.
5 minutes.
Yeah.
Okay. And Mr. State, do you need a time remaining?
Same, 5 minutes.
I'm sorry?
Same.
5 minutes?
Yeah, fine.
All right, counsel, y'all come in 8:30, 8:45, so that we can present whatever final motions that need to be presented, and we will go from there. All right? Thank you, everybody.
Thank you, Judge.